Hello, good evening. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here on live to take your U.S. immigration related questions. So go ahead, put your questions in the comments so that I may answer your questions today. But I also have a good topic for you. And I'm going to be talking about getting the work permit and the green card through the process called VAWA. So you'll often, if you follow me, you'll often see that I talk about this in videos, and I post a lot about this form of relief. And, when I discuss VAWA, I talk a lot about the spousal relationship and how you're able to get VAWA through that spousal relationship with a U.S. citizen or legal permanent resident if they are mistreating you. But there are other options if you are being mistreated by a parent and you're under 21 or you're under 25, and also if you're being mistreated by a U.S. citizen, son or daughter who's 21 and up. So the spousal relationship isn't the only qualifying relationship for VAWA. Also, I want you to know that if, say, even in there are other types of relationships that may qualify for other forms of relief, immigration relief, and I'm going to briefly touch on those too. So let's talk about the parent-child relationship and how that can lead to qualifications for VAWA. Now, if you're being mistreated by a U.S. citizen, son or daughter who's 21 and up, so let's talk about that. Even if you're out of status, even if you cross the border without permission, if that is the case and you're being mistreated by your child, once again, mistreatment is defined broadly. Remember that mistreatment and forms of abuse or extreme cruelty comes in different forms. It doesn't necessarily mean that you're going to be physically abused or harmed, but it could also mean that you are verbally abused, you're emotionally abused. Maybe that U.S. citizen, son or daughter, they are intentionally vindictive towards you, or they do willful things to hurt you. Now, there may be certain situations that have resulted in your citizen son or daughter doing this. If, for example, they have a history of substance abuse, and because of that substance abuse, it is now causing them to mistreat you, you could still qualify for this. Also, if you are in a situation where you are being if you are they say they have emotional issues, they have emotional trauma, and they're also turning around and mistreating you because of it, then this could also mean that you could get VAWA. And this is permanent resident. So it's permanent resident. While you're waiting for permanent residence, you could apply for your work permit. And so how it works is, first we apply for VAWA, and you would also be able to apply for your adjustment of status. That means you'd stay here to get the green card. And while you're waiting, you would be able to get the work permit. Work permits are taking anywhere from 4 months to 11 months. But once you get the work permit, it gives you some relief while you're waiting for the rest of your process to go forward. First, a decision on the VAWA. There's no interview, so that's where it's very important to schedule to put together a good application. Then once they make a decision on the VAWA, you could expect one between 18 months to 2 years. Then it moves on to the green card phase. But while you're in the green card phase, guess what? You're able to work and move forward and stay in the United States, even if you're out of status. Thanks so much for the love. I appreciate it. Now, what about if you're the child, right? And when I say child, you could be under 21, or you could be under 25. If you're under 25, and the reason you waited, you have a good justification for waiting, and it is based on the mistreatment that you experienced, then that could also qualify you for VAWA. Normally, it's when you're under 21 and unmarried that you could apply for this based on mistreatment by a parent. Now, keep in mind that mistreatment by a parent includes, for example, if they have been a deadbeat parent and they have willfully neglected you, they have not provided for you. Say you got beaten a lot. Say you got beaten, in situations where it was uncalled for. If the parent did vindictive things to you, even as a child, going up into your adulthood, these could qualify you. So normally it's if you're under 21. However, if you are under 25, this could possibly still work for you. We would have to look at the reason you did not file for this when you were under 21. But it is very possible to still move forward in your process. Now, what does this process look like once you filed? So we help our clients to put it together, and we put a thorough application together. Now, any credible evidence counts. So that means any evidence that's believable evidence. That could be your declaration. Your declaration, of course, it has to be drafted thoroughly. It has to be in sufficient detail for the officers to accept it as evidence. But in cases where, it's hard to gather evidence, it's hard to present evidence, especially if it's been a long time since you faced that abuse, then other types of evidence, credible evidence. So we usually brainstorm with our clients to figure out what the best forms of evidence would be to show this mistreatment. And as I said before, it includes all sorts of mistreatment and extreme cruelty. So not just mistreatment, but extreme cruelty as well. I would say if your relative, the qualifying relative here, so your spouse, right? Today I'm focusing on the parent-child relationship. So if you're a parent or your son or daughter who's 21 and up mistreated you, then it's time to schedule that consultation. Let's evaluate your case and figure out if you could qualify for this. The good thing about it is also a way to get on track with your immigration status. So if you overstayed, if you are cross the border without permission, if you entered with someone else's paperwork, you could still qualify for this. There are ways to apply for forgiveness in the case that you have past immigration violations. And even if, say, you've been arrested because of, and that arrest was related to the mistreatment. So say you had a domestic issue, you were arrested because of that, or your relative blamed you for that when it's related to you being victimized, then this could also be forgiven or overlooked because it is related to the abuse. So, if you are in a situation like this, go ahead, schedule that consultation, because this could be what the hope that you need to move forward to move forward in your life, to gain status in the United States, to be able to work, live, and gain a path to eventual permanent residence and citizenship. The entire process takes about 2.5 years, but keep in mind, right during the process, you're able to get your work permit and your travel document in some cases to move on with your life. You can also apply for this even if you're currently living with this parent, this son or daughter, or this spouse. I use this address, my office address, as a safe address so that my clients are safe through the process, and it's confidential. So the parent, the child, or the spouse are not notified. As a matter of fact, if you call about your case, they will not talk to you. What we do is we communicate with the VAWA unit, the people that make the decisions, through an attorney hotline. And that's the only way that they will communicate. Otherwise, you have to do it through snail mail, which is a lot more frustrating because it could take weeks, even months, for them to process whatever you request or information you need by mail. So another reason why representation makes a difference in this case. So now I'm going to go to questions, and I see, let me go through, make sure I'm not missing any. All right. So as a US citizen, can I apply I-130 for my parents, my spouse, and sister at the same time? So you can apply for your relatives, multiple relatives at the same time. Now, whether they will all get through at the same time, that's another matter. Keep in mind that processing times are longer for some than others. For example, sibling petitions take 14 years right now, minimum of 14 years. Parent-child the parent-child can take anywhere from 5 to 7. Depending on the marital status of the child and the status of the parent. So that's where it's important to really schedule that consultation and sift through what's going to make sense for you and your family. Now, if you'd like to schedule a consultation, go to the link in the profile. It's going to take you to the website where you can then schedule your appointment on the website, on the Contact Us page. There's also a button on the homepage that says schedule your consultation. There's a phone number there. There's the contact form. There's an online chat. All of those lead to the scheduling coordinator who can then help you to schedule. You're welcome, Jerry Horace. Nice to see you. Good day. How long does the green card take to be processed in 2022 since I'm at the age of 21? So if you're being sponsored by a US citizen or legal permanent resident parent and you're unmarried, you could be looking at 5 to 7 years. Is the I-130 taking long to approve this year? The next 2 weeks, my I-130 will pass normal processing time. So it's taking, I'm seeing an average of a year for the I-130s. A year, 9 months to a year to get those approved. Is the I-130 taking longer? This year, my husband filed for me, but next Friday it would be reached out of normal processing time. So I would say about a year is the average processing time, but it also depends on what's going on in your particular case. Does the VAWA have an age limit or does extend outside parent-child relationship? Great question. So yes, there is an age limit and it's usually under 21. If you're the child and you were the one who had, you were facing mistreatment, generally it's under 21. However, if that deadline has passed and the reason it has passed is because that delay was related to the mistreatment that you face, then that could be an acceptable excuse that the USCIS will accept. I do help my clients to navigate that process and determine whether they can move forward, but you do have to be under 25. If you've reached 25, at that point, it would be too late. When it comes down to the parent, the child that's doing the mistreatment has to be 21 or older. Even if, say the child was a drug addict at 18, and they really put out their addiction on you as the parent, and now they're 21, you could still file for this petition, given you qualify in other ways, of course, that you meet all the requirements. If I apply my sister's I-130, since it takes 14 years, what if my own son wants to apply for her before it approved from my side? Can we switch petitioner? So that's a very specific question, and that's where you're going to have to schedule a consultation. Do I qualify for VAWA if my husband and wife refuse to do my paperwork? So I can't confirm here. That's where the consultation is going to be very important, naturally, Kills, to determine whether you qualify for VAWA. What I can tell you, though, the starting point for me is when I hear that a husband or a wife, they refuse to file for you, it means that there's a larger problem going on, because I don't know any caring spouse that would refuse to file the paperwork for their spouse. So at that point, that's where I do a detailed evaluation to see, because even if they refuse to do the paperwork, that in itself is a sign of mistreatment. But I'd have to evaluate your other facts to determine whether you would qualify, and whether you can meet the other requirements, because mistreatment is one, but that is definitely a central factor in applying for VAWA. But remember, there are other requirements too that you also have to meet. And so that's where the consultation is going to be very important. Now, it is worth it to determine whether you qualify, because this VAWA process, if you qualify, can make you unstuck. It could get you out of your situation. And keep in mind, you can still be married and filed confidentially. You can still maintain confidentiality through the process. That's what I do for my clients. Is I present a safe address, and I also advocate for my clients before the USCIS. All right. So I don't see your previous question. So I see your question. Does anybody see my question? But I don't see your question. So can you retype that question? I don't know if there's a technical glitch going on. And naturally, Kells, you're welcome. Get that consultation. It will be worth it. I have a question. So attorneys determine their own fees. And so whether or not that's too much is not a question I can answer, because attorney fees are going to be different. The kind of case is going to be different. What's going to be required in order for the attorney to successfully represent you? So I wouldn't be able to answer whether another attorney's fees is too much. How much is your consulting service? So it's $150 for up to an hour. And that my consultations are very detailed. So I don't just glaze over your issue and then send you on your merry way. The first is I want to make sure that you are fully informed, that you understand your process, that you can qualify for certain immigration relief, even if you don't know about it, that I can inform you about those forms of relief if you qualify. And then I am also very much interested in advocating for you through the process. So we go through a detailed evaluation, and then we determine whether you qualify, and then I provide you your options. So where is your office? So I'm located in Boca Raton, Florida. However, keep in mind that I'm all over the country. So I represent my clients all over the country and the globe. So I have, no matter where you are, whether you're in Africa, whether you're in a country in Africa, whether you're in a country in Europe, whether you're in South America or the Caribbean, whether you're in another state, I can represent you. So go ahead and schedule the consultation and allow me to help you. Now, my consultations, if you're not close to me, is going to be by phone or video, and I leave it up to you to decide at the time that you're scheduling. The way you're going to schedule the consultation is by going to the link in the profile. It's going to take you to the website. When you get to the website, go ahead and see how you want to contact us. Do you want to call? The number is there. Do you want to just fill out a contact form and leave it for us to call? The contact form is there for you to do that. Do you want to do the online chat from the convenience of wherever you are? Yes, you can do the online chat. All three lead to the scheduling coordinator, who will be more than happy to help you. You can also schedule on your own. So say you don't want to even call, you just know, I just need to get this scheduled. That's fine. Go to the link in the profile, and you will see, it will walk you through the process of confirming an appointment. How long does it take to get work permit with a marriage-based green card? So right now I'm seeing about 3 months. If an undocumented immigrant who is a cosmetologist in the States, would they be qualified for entertainment work visa as an artist? So if you're undocumented already, I doubt very much you'd be able to get a visa. In order to change status, to get such a visa, or to be able to get that visa, that work employment-based visa, you will have to have legal status. There are options available for undocumented immigrants, but this would not be it if you're already undocumented. How long do you have after a denial? Can you still file VAWA if you have separated from your abusive spouse? Perfectly flawed since 1990. This is an important question, because while I don't know your situation, that's where a consultation is very important. Many of my clients have been through the process. They've been denied because the spouse sabotaged them in some way, and they're still allowed to apply for VAWA. However, you still have to meet those requirements. Not because you've been denied means that you can just go for VAWA. That's where the consultation is going to be very important to determine whether you can qualify for this, and then get started ASAP. Now, if you've been denied, it means that you need to get that legal advice ASAP to determine whether you can move forward on your own. Because, you know, the longer time that you take, it could mean complications, could mean delays that could make your situation just more tedious. So get on it, give us a call, schedule that consultation. My cousin recently got denied renewal for visitor's visa. She was told she doesn't have enough from her job. Is that a typical reason? Yep, it is. Do you need to have an unexpired visa to file? Great question again. The reason VAWA is such an important form of relief is because it provides an form of immigration relief for undocumented immigrants. It is for immigrants who they're here legally, they have status, but most importantly, it is there for immigrants who don't have status. It doesn't matter if you cross the border without permission, if you are here and you overstayed, it's still there for you. Because remember, the focus of it is to provide much needed relief to someone who was abused and you know, used and abused, and they were in a situation where they didn't have the power to apply. And so they're trying to rectify that situation for the immigrant who has faced extreme cruelty or mistreatment or abuse. Now, I just want to reiterate again that abuse, mistreatment, extreme cruelty could be verbal. They don't have to hit you. You don't have to get the police involved. A doctor doesn't have to sign off and say you were physically harmed. Those do qualify, mind you. But I have clients that range from purely emotional mistreatment and extreme cruelty up to, you know, the types of physical abuse. But in my book, when you are being mistreated, and also when we consult with therapists who can speak to, they can lend their expertise to forms of abuse and mistreatment. These are the same. The effects of them can be the same, no matter whether you were physically harmed, abused, physically threatened or not, verbally, emotionally. They all lead to trauma. And so I make that clear when we are filing and putting a good application together for our clients. Can my husband file for me as a permanent resident if he got his green card through marriage? Great question. So it depends. If 5 years has not passed, then he is going to likely be denied unless he can show clear and convincing evidence that his previous marriage and his current marriage to you are real. If I overstayed on my visa and I'm married to a legal permanent resident, however, he will be able to file for citizenship soon. Doesn't make sense for me to wait it out. That's very detailed, and that's gonna need you're gonna need to schedule a consultation. What if the work permit and temporary social after denied interview? Does that affect VAWA, seeing I'm separated and got those while married? So perfectly, that is a very specific question. That's where the consultation is going to be very important. Remember that the information I'm giving you here is general. What I do want you to know here is that you have options. And now I leave it up to you to seek the advice and representation you need in your particular case. But I wouldn't be able to get into all the nitty gritty of your case until we are in a consultation and I can sift through all your facts, do the follow-up questions, and give you reliable legal advice. All right. Thanks so much for all of these questions. They were very relevant, and I am going to go ahead and look out for you to schedule that consultation where we can talk more about your particular situation. I want you to know that this is an important form of relief that can it can change your life. And that is why I emphasize that I give that information. Because I want you to understand. A lot of people don't understand understand how the process works and how it can help them to get their life straight, to be able to recover, gain independence, and move forward in the United States. So I hope I've given you good information. I will be back tomorrow, so at 4:30, where I will continue to bring information to you about possible options. And I like to highlight options where you're undocumented, but I also work with clients to get, even if you're in status, where you can gain employment-based permanent residence. So I practice employment-based, family-based, and humanitarian. Humanitarian is where you've been abused, you're applying for asylum, you've been the victim of crime or trafficking. So if any of these issues are familiar to you, get on it, get that legal advice. It's the way that you're gonna change your life. Make that investment. Have a great evening. Thanks for your time. I will be back tomorrow. Thanks, guys. Bye-bye. All right, so before I leave on YouTube, I just saw a question here, and it's how long do persons get a travel document through VAWA? So it takes about the same amount of time as the work permit. Right now, it's backed up, but I'm seeing anywhere from 4 months to 11 months. So you should prepare for that time range. Go ahead, schedule that consultation. Go to the About page, and you'll see the link to get to the website there. Go there. Give me a call, schedule that consultation, and we can help you. Have a great evening. Bye-bye.